Amy Burke, who will be discussing IP law, intellectual property, and all of the things you need to know as a small business owner. So welcome, Amy. We are super excited to have you. Thank you so much for joining us today and kind of discussing all of the ins and outs of intellectual property with us.
Happy to be here. Thank you.
Great, awesome. I guess first we'd love to just do a bit of an intro on you. Tell us a little bit about yourself. Give us a bit of background on, your experience. Also, just how you got to being sort of in intellectual property, and sort of a TLDR on yourself.
Sure, absolutely. So I've been practicing for about 13 years, practicing law, and I knew that I wanted to go into intellectual property when I went to law school. I started my education in philosophy and linguistics, and I was really interested in and remain interested in complex problem solving and also in education. So I was thinking about going into a career in academia and philosophy, and then I started thinking about intellectual property, worked in a law firm, actually as a paralegal for a while, doing trademark work, then went to UCLA for law school, graduated and worked with firms in Los Angeles, a boutique firm, and then some mid-sized firms doing intellectual property transactions and litigation. And so that's how I got started. And really what drove me to do it was to help businesses and actually interact with people in doing creative problem solving and facilitating understanding.
That's awesome. I think we could probably start off with some of the big question, which some people wouldn't necessarily know how to answer, is what is intellectual property? So maybe you can kind of give us sort of an intro into what specifically it is. Obviously, I'll kind of dive deeper into, a couple of other questions, but maybe just sort of an overview of what intellectual property is.
Absolutely. So generally, intellectual property, it's intangible property. So real property, such as real estate, people are very familiar with that. Intellectual property, it's divided into different categories depending on the type of thing that's being protected. So there's trademark, copyright, patent, trade secret, and then there are some other things like right of publicity that go into there as well. But the first four are really the primary elements. And so trademark that's a brand. It's what the source identifier for your business. So people look for your business. This is the name, the logo, the packaging, the design. This is what they look for when they see your business. Copyright is creative works of expression, and there's a very large range of things that fall under that protection. And then patents are either inventions or unique designs. And trade secrets are basically just that. They're proprietary secrets that are kept secret for your business. And that's an interesting kind of protection that can last in perpetuity, so forever, potentially.
Cool. Okay, before we dive a little bit deeper into the types and all of that, sort of what inspired you to specialize in IP law?
Well, so I started my academic career in philosophy and linguistics, and I became really interested in trademark law because of the language aspect of it. So there are a lot of interesting issues that come up in terms of, for instance, when you choose a trademark, you have to choose a mark that doesn't describe your goods or services or what you're doing. And so that kind of gets into the semantics, into the meaning, into what people understand. And then in looking at things like copyright, I think it's a really interesting question. What should be protected? And that changes over time. It changes with technology. It changes with our understanding. So for instance, software, should that be copyrightable? And it raises some really interesting questions.
Cool. Awesome. So another sort of different question, going specifically deeper into IP. Why is IP important for entrepreneurs to consider when they are first starting their business?
Absolutely. So I like to think of the business journey, the entrepreneur's journey, as just that. It's a journey. A lot of people talk about it as sort of building your castle and that kind of thing. But it seems to me that for most entrepreneurs, you're discovering your own journey, you're determining your own path in terms of what you want to accomplish. And I think that knowing about intellectual property, it's a way to understand the landscape, to kind of have a map to figure out what you can and can't do. And so knowing the basics, the fundamentals of intellectual property, especially trademark and copyright, and for some people, patent, at the very outset will help you build a foundation for your business so that as you progress and as you proceed, all of the time and energy and resources you're putting into building your business goes into expanding your business rather than into litigation and lawsuits and disputes with other companies.
Cool. Okay. I think one of the things that I guess I'll use as an example, we can use Mercado as an example, just to share, I guess, examples of the different forms of IP, right? So trademark, copyright, rights of publicity, patent, trade secrets, etc. So an example of a trademark would be the Mercado name, right? And then a trade secret would be anything that would be sort of code for our app, for example, correct? That would be considered trade secret.
Possibly, or even something like your customer lists, your any kind of internal processes, things like that. Yes.
Got it. Okay, cool. And then what would be things that would be, I guess, copyright? Would it be specific language that we use in our marketing efforts? Or I guess what would be another example of something that's copyrightable?
Absolutely. So, for example, if you in your marketing efforts write an article and it's something that's informative, it doesn't have to be something that's directly related to marketing, but something that's for the community. And if it's your original creative work of expression and it's written, the company automatically owns a copyright in that. And so where that kind of might come up in terms of the business is, what if a third party takes that article and posts it on their own website? And that's where the copyright rights kind of come into play.
Okay. So I guess one example of patent then would be if we were to create some sort of revolutionary technology that was new to the landscape, then patent law would come into play at that point, right? Or if a small business owner created some sort of new invention that has never been created before, that would be an example of a patent IP type of law that they could protect themselves under.
Exactly, that's right. And one interesting thing about patent is that for in the United States for trademark and then worldwide for copyright, just creating and using it will create some rights. Like creating and using a trademark in the United States, you start to create what's called common law rights. A copyright, as soon as it's fixed, so as soon as you type it out or you take the photograph, you own rights in it. For a patent, however, you have to go through a patent office. And so if you were, for instance, going through the United States Patent and Trademark Office, you have to apply for registration of the patent. And there's significant time constraints. And so that's a place where it's important to recognize when you might have an invention that's protectable, and then go talk to a patent agent, patent attorney about protecting that.
And the biggest piece and takeaway I would say from that is do that upfront and as soon as possible, be it trademark, be it patent, be it trade secrets, just so that you are sort of protected as a small business owner.
Absolutely.
Okay. I know this is sort of a side different question and something that I just thought about. Generally, I would assume that a lot of the time these take a while to actually get, sort of in process, but then also approval for, because, there's just a lot of red tape that the various offices need to go through. Can you give a little bit of I guess, a synopsis on what that process is like?
Yes, absolutely. So let's start with copyright. It's the easiest. So for copyright, you have the right as soon as you fix the work. However, in order to go through and get the registration, which in the United States, that's important to establish your rights. And it becomes important in litigation in terms of being able to determine damages and that kind of thing. So for copyright, usually the process after you apply, it takes about from 6 to 9 months generally for the United States Copyright Office to review the application, process it, and provide a certificate of registration. Sometimes they'll come back with a letter where they need more information if there's something that's amiss. So that's kind of the general timeline. For trademarks, when you apply for federal registration, you usually get an initial response within 6 months from the trademark office. And if everything goes very smoothly, the whole process can be done, depending on the workload that the trademark office has, between let's see, 9 months and a year from application to registration. And then patents, it really varies in terms of the type of technology, the amount of back and forth, but that can also be, you know, definitely upwards of a year or two. So those are the kind of the general timelines. I do want to say, though, regardless of the amount of time that it actually takes to get registration, it is important to get those applications in, because for each one of those types of rights, there are reasons why you want to have it on record that you're applying for those rights at the time that you're applying for them. So getting that application in for the trademark registration, for instance, that can put you ahead of others. For copyright, it can have to do with damages. And then for patent, you have to apply within a year of public disclosure of your invention, or you lose the right to patent, just generally. So timing's important.
Okay. Yep, clearly. Awesome. Thank you for that. I appreciate it. I guess one other thing, and I want to just make sure that anybody who's a small business owner that's watching really sort of gets a full scope of understanding for each of these, because, you know, there's so many variables and, you know, potentials. Would you mind sharing a couple of extra examples of how sort of each of these would come up for a small business, and how, you know, and how people can protect themselves?
Absolutely. So let's start with trademark. So let's say that you're launching a small business and you have your core brand, whatever that may be, your core brand name. And that is how your customers are going to find you, et cetera. For the common law rights that I mentioned before, so when you start getting rights, that's in actually using the mark, so providing goods or services to the public for sale. But you can also apply for what's called an intent to use application with the United States Patent and Trademark Office. So that sort of holds your place in line. So even if you aren't already using the mark, you can get in there and have that priority date. So if some third party starts using the same or a similar mark, you're in before them. And that can be really helpful in terms of research and development, so that you aren't putting money and time and effort into a brand that might not be protectable. An example with copyright would be, and it kind of goes both ways. It's protecting yours and then also making sure that you're not infringing others' rights. So for example, when you launch your first website, if you're using graphics or music or photographs, anything that your company did not directly create, it's important to think at that point about who owns this content. Is it something that I've properly licensed? Is it something that I need to ask permission for? Should I take it down? Because that's another thing that can lead to potential issues. And then for instance, for the trade secret, let's say that you have a personal care product with a particular type of formulation. So your formula is very important to your business. Well, from the very beginning, have agreements in place, non-disclosure agreements, confidentiality policies and procedures, so that that stays secret.
Yeah.
So those are some things that people can do kind of at the very beginning that really will just set them up for success.
Great. Thank you for that. I appreciate it.
Sure.
I'm going to switch the conversation up a little bit, and I guess go into sort of the creation, protection, and then long-term maintenance of what are trademarks, copyrights, etc. Right? So I guess, what are some of the considerations a business owner should think about when creating their brand? So, you know, I've created this small business. Where do I start, and how do I get that? You know, I guess, what do I think about, and how do I get that process started?
Yeah, that's a great question. So one piece of advice that I think is helpful to all business owners who are thinking about creating a brand is, when you create a trademark, the idea, the kind of legal background and the public policy, the idea is that you want the public to know that this good or service comes from a particular source. It comes from your business. So in choosing the mark, it's important to choose a mark that's inherently strong. And what that means is, the farther away you can get from being descriptive of your goods or services, the better. And so a simple example, the word apple, you wouldn't be able to get a trademark for that for use with selling apples. or for selling apple pie.
Yeah.
However, you can absolutely protect it for use with computers because it's not descriptive. And so choosing a mark that's not descriptive is important because if it is descriptive, third parties can come in and use it with the justification, and often the reasonable justification, that they're accurately describing their goods or services. So make sure it's not descriptive. And then also make sure nobody else is using it. And that's not just people who have trademark registrations. Because in the United States, you can also have common law rights, it's important to just do a general search to see if there's anyone out there who's using the mark with goods or services that are anywhere similar to yours. And that will avoid a lot of problems from the beginning.
And that general search you can easily do by going onto Google. You can go onto the trademark office website as well and sort of do some of the research there, or engage with an attorney specifically to start that process.
Absolutely,
Cool.
yes. Mm-hmm.
One other question that often comes up is, what are the specific pitfalls one should watch out for?
Right. So I think in terms of trademark, one specific pitfall is it has to do with the descriptiveness, whether a third party is already using it, and just making sure that that's as thorough as possible. And also ensuring that when you do choose a trademark, it's very important at the point of it is to convey that this is coming from a particular source. So trademark is all about quality control. So if you license your trademark to third parties, or if you're licensing it from a third party, there have to be quality control provisions in place so that if there's a product or a service that's coming out with your brand on it, you need to make sure that you're controlling the quality of that. Another major pitfall in terms of copyright is there are a lot of very, very widespread common misconceptions about copyright infringement. One that I've heard quite often is that if you change 20% or if you change 30% of a design, you're not infringing. And that could potentially be a guideline in some circumstances, but there's no such rule. And the better kind of a way to go is, if you're using someone else's work, think about whether you need to ask permission, using it in any way. Because if you use it in any way, then what you're doing is creating what's called a derivative work. And so make sure that you have permission to use everything that you use, because that can lead to problems. One other very common pitfall, and I think one that's important in today's market, is before you use, especially someone who's high profile, celebrity, before you use anyone's name, likeness, image in any way, make sure to have written permission. Because let's say that you have a photograph of a celebrity that's holding a bag from your store. If you post that on your website, you're implying that they're endorsing your brand. And so you need to have their permission first.
Awesome. Thank you. Can you share with us what you feel are some of the most important questions small business owners should be asking their attorney around their trademark or their copyright, etc.?
Yes. So I think in engaging with an attorney, one of the most important things to look for is clarity of communication. As a small business owner, you deserve to have representation from someone who's responsive, who can explain things in a way that makes sense, and where you have a strategy and a game plan that comports with what your vision is for your business. So I think that getting that clear communication. Another issue is making sure that you understand the full scope of what it is that you're asking them to do and what they've promised to do for you. So, for example, if you're registering a trademark, do you want it just in the United States? Do you want to go internationally? And if you do, what is that going to look like? So kind of looking at the whole picture, I think, is really important. And then in terms of looking at things like fees, in a lot of IP contexts, lawyers are moving toward more of a flat fee model. It's the model that I prefer because nobody likes a surprise bill. But there are other contexts where it really is necessary to do hourly. And so I think that having a really clear understanding with your attorney of what the budget estimate is and whether or not that's in your budget. It's an important part of the business, because being able to budget for that and plan for that is what's going to set you up for success.
Totally. Are they sort of, I guess, separate to what would be an attorney's fees, right? Can you ballpark what would a trademark cost a small business owner?
Absolutely. So if you do a federal registration for a trademark, so through the United States Patent and Trademark Office, the fees are all listed on their website. But one example is if you do an online application, single mark in a single class of goods or services, so just all goods and services are divided into classes based on general categories. So if, let's say it's one mark, one class, the filing fee right now is $225. And then there are additional fees if, for instance, you're not using the mark yet and you have to file a statement of use. So that's kind of the general ballpark. For copyright, it depends on the type of work, but those fees are generally under $100. And that's also an online registration process. For patents, it really varies depending on whether you're a micro business or a larger business. And for patents, it really is, unless it's someone who already has a lot of knowledge in the field, and I'm not a patent agent. Patent agents are people who have hard science undergrads, have taken the patent bar. So it's a very specialized area.
Sure.
So working with someone competent, that's also very important in that context, to be able to get a patent that's actually, worth anything, right? That achieves your goals.
Sure. So making sure that you work with the right attorney based on your needs is also key to success.
Absolutely. Absolutely.
Awesome. Okay, great. I do want to leave a little bit of time for any questions that come in from anybody who is joined us today. So let's see if there's any of those first, just because I know I want to be sensitive to timing. And one of the things that I think we can take a look at as well, and that potentially could be a question, is well, we've talked a little bit about price, but how do I create a logo that I can protect? So obviously there's nuance to what is design, right? And so how do you sort of approach the design element of what is your IP?
Right. That is an excellent question. So, and logos are actually interesting because they can be protected by both copyright and trademark, depending on how kind of complex the original design is. So, in designing a logo, the ideal way from a legal perspective would be for someone to sit and, from their own mind, create something without using any external material. Now, that's not usually how the design and creative process works. So if you want to start with something, start with some sort of a template and inspiration. It's a great idea to start using content from, for instance, a database of public domain materials. So materials that are no longer under copyright, for example, or open source, like Creative Commons licenses are really interesting because people can kind of determine what the scope of their copyright is going to be for a particular work. So I think making sure where you start, that's important. And then when you're looking at the trademark protection piece of it, to make sure that no one else is using a similar tool, it's always a good idea to use Google image search, TinEye, different kinds of search, an online search methodology that would show you similar images. And when you're looking at that, think, if you were a consumer and you were to see these two images side by side, would you be confused? And if the answer is yes, then that's where the problem comes in.
Got it. Cool. Okay, so one of the questions that came in is, I really like an Instagram video I saw on someone else's profile. Can I use it on mine and just caption a credit to the creator?
That is a great question. It's interesting because there are a lot of myths about copyright and use on the internet. The basic rule is, if somebody else created it, you can't use it without permission. So the best way to go about it, both from a legal and just from a public relations and kind of moral standpoint, ask ask the person in writing if it's okay to use. Explain how you're planning on using it. And if you get that permission, wonderful. If not, I would just recommend don't do it, because it's not worth it, and it's not the kind of business practice that really I don't know, would lead to success and will lead to other people respecting your intellectual property.
Better to be safe than sorry.
Yes.
Yeah, got it. Another question that came in: for my social media campaign, I'd like to have music in the background of my videos. Is that okay?
And that is another great question. Also, something that's very common for there just to be an assumption that if you want to use somebody's music, you can. But if it's not something that you composed, performed, and recorded, then other people likely have rights in that music. So what I would recommend is to go to different databases and resources where you can find music to license for those particular purposes. And that way you make sure it's all above board. And I think that this kind of goes to a broader issue, which is it might be tempting to use those kinds of things, but one way that I like to think about it is if you were the one who created that, if the individual wants to use it, we're the one who created the music. Think about how you'd feel if someone else used it. And so it's the idea of being kind of equitable and fair, and making sure that that intellectual property is used responsibly.
Cool. We have another question that came in, and we kind of touched on this a little bit, but how should I choose the right lawyer for my business? So I think I'll let you answer that, but we kind of touched on it a little bit. I guess, can we expand on that?
Absolutely. So um, there are a lot of lawyers out there, and I think that there are a lot of really interesting changes in the legal industry right now. I worked with firms for many years and decided to go out on my own so that I could really focus on transactional work, so on helping businesses grow and develop, and not on the litigation side of it. And there are there's a wide variety of people you can work with. And um, in post pandemic, I think, or because of the pandemic, I think that a lot of attorneys who were very used to just working in their offices now have kind of expanded to be able to work with people remotely as well. So I think that the key is to find someone who you really can communicate with, and who you feel understands your business and has your business interests in mind. So and it should be someone, I think, who can educate you about the things that you want to know about, and where you really feel supported and understood.
Makes sense.
And I guess
We
one
have
thing
a
that I
oh,
need
go
to add to
ahead.
that,
Sorry.
sorry, is that it's also really probably the most important part. Find somebody who really knows what they're doing in this area, and make sure that they've done it before. So if it's somebody who does, one type of like immigration law, that person might not have ever done trademarks before. And there are very specific things that a trademark lawyer would know that'll be helpful.
So look for the right attorney, make sure that they understand you and your business, and then find sort of that balance between what you need and who is doing the work for you.
Exactly. That's right.
Great. We have about a minute left. So are there any last sort of things to leave the audience with today that you'd love to say? I know that we covered a lot, so I feel like this has been really productive though, and thank you so much for the examples. Are there any sort of last thoughts you'd love to leave?
Sure. I think just to keep an open mind about intellectual property and the genuinely interesting things that can come up. I think that it can be a really daunting thing to think about, but I found that for a lot of people that I work with, as they go through it, they actually find it interesting and fun. So look at it as a really productive, beneficial part of your business journey, and embrace it.
Great. Thank you so much. And one thing that I do want to leave everybody with is that this is just a reminder that this conversation was for educational purposes and not explicit legal advice, and to really contact, an attorney in order to get any advice needed. So thank you so much for joining us today, Amy. Really appreciate it. And we will definitely be in touch soon.
Okay, wonderful. Thank you so much.
Thank you.